Mr. Collett.
Hello. I'm moving on now to my second heading, which is the correct approach to construction of the default clause. And I'm going to make 5 brief points of principle. First, as we know, the GAFTA default clause appears in a wide variety of GAFTA contracts. And it's apparent from the decided cases before you that it appears in both C&F and FOB contracts. For example, Bungi concerns an FOB contract. And the general observation is we would therefore expect it to be workable in both the FOB and C&F contexts. The second point is that as it's a damages clause, it would be expected that it would dispense with some of the complexities of assessment in accordance with the Common Law and the Sale of Goods Act. Otherwise, there would be little point in including a damages clause because you could simply apply the Common Law and Sale of Goods Act principles. It follows, I suggest, that the clause should be interpreted with a predisposition towards a meaning which promotes simplicity, certainty, and predictability in the assessment of damages. The third proposition is that where the Supreme Court has stated an interpretation of the relevant provision of the default clause, even if technically obiter, it should be presumed that the users of the GAFTA contract and GAFTA arbitrators will have relied on that interpretation. I suggest that it follows from that this court should be slow to depart from the interpretation stated in Bungi. The fourth proposition is that the view of trade arbitrators applying a standard clause from their own trade should be given some weight. So this is a case where the appeal board in para 7.37 of the award, and we've looked at that now a number of times, emphasized the role of the clause in avoiding, as they put it, complications, and they referred to it as, quotes, a mechanism by which the parties have agreed to simplify the assessment of damages. That is on page 245, award para 7.37, the long passage that we've looked at. And the fifth and final point is that it's important to note that Sharp does not say that Viterra's construction is not an available meaning of the relevant words in subclause C. Sharp accepts that in certain circumstances, the actual or estimated value of the goods can be measured by reference to a notional substitute contract on the same terms as the original contract. All that Sharp disputes is that this is the or an applicable measure in all circumstances.
Do you say that the measure by the arbitrators is a measure on the same terms?
Yes, I do.
I mean, I was just reflecting over lunch on your observation, seems to me, if I may say so, right, that we should be looking not at the goods, but at the bundle of rights, as it were.
Yes.
If one thinks what were the rights worth that the sellers had on the default date in relation to the goods situated as they were, is there any reason to think that those rights weren't appropriately valued by what an Indian buyer would pay situated in the position of the related company, but independent, would pay for those goods?
Well, I mean, I'm not sure that's not a question that can be answered yes or no, in the sense that it depends on the terms. I mean, if the question is, would what an Indian buyer was willing to pay for the documents represent the value of those rights, then the answer would probably be yes.
I mean, an Indian buyer stepping into your shoes would be able to get instant access to the goods from the warehouse. They wouldn't have to ship them from Canada, have them shipped from Canada and pay import charges or get them customs cleared. And it seems to me that your measure of damages in B, or whatever it is, the question, bears no relation actually to the value of the goods on exactly the same terms, even as this contract, but in relation as it then stood.
Well, I mean, there are two different points here, though. There is what the tribunal said they were doing, and there is the evidence by which they made their decision. What they said they were doing, as we've seen, is they said they were assessing a value on the terms of the contract, so C&F, FO, Mundra, on the international market. The evidence that they used to perform that assessment was to take an FOB price and add the freight. And in principle, there is nothing wrong with that as a way of getting to a C&F value. It's a commonly adopted method of doing it, and it was the only evidence they had before them. So unless it can be shown that there was some error of law in their doing that, and I suggest there isn't, then the fact that that's the way they did it cannot be criticised, and the only question is whether what they were trying to do was the right or the wrong thing as a matter of law. Now, you can cavil at whether it might have been put to them, but it doesn't seem that it was, that you can't simply take the C&F, you can't simply reach the C&F value by taking an FOB value and adding freight without adjusting for the time difference in terms of shipment and so on. Or you might say there are other ways that they could have done it and better ways. But that was the evidence they had, and that was the evidence they accepted.
But this is the question of law posed to us is to whether, as a matter of law, the clause requires them to take the theoretical cost on the date of default of buying the goods, FOB, and et cetera, or whether they should take the market value of the goods at the discharge port.
But that comes back to the way that the question has been framed, which I've already said is inapt to capture the real issue, because it's mixing the point of principle and the way that the point of principle was applied to the facts of this case, all in the same question, which is why the question is not a particularly good one with respect in the way it's formulated. And that's what we've always said.
You may not like the question, but at the moment I don't see how one can say that the clause can be interpreted as requiring somebody to take the theoretical cost on the date of default of buying the goods, etc.
Well, on the contrary, I would say I don't see how it can be said that that necessarily betrays an error of law if the purpose of doing that was to reach a C&F FO value on the terms of the original contract.
Well, I won't stop you any further. One would have thought the basic ultimate aim is to provide some relationship to what compensates the loss and doesn't pay somebody money for a loss they haven't suffered.
Well, that
couldn't reasonably have suffered.
That brings us back to the fundamental question of what subclause C of the GAFTA default clause requires.
Yes. Yeah.
But my last observation on my fifth point was going to be that the ultimate construction issue is whether actual or estimated value is always to be determined by reference to a notional substitute contract in the same terms as the unfulfilled contract, or whether there are some circumstances where it doesn't have to be determined in that way, and if so, what they are. But I can move on to the third heading, which is the key authorities, starting with Bunge and Nadira, which is in the authorities electronic bundle, page starting at page 521. By way of preamble, it's wrong of Sharp to say that the default clause played no part whatsoever in the result reached in Bunge and Nadira. The meaning, and particularly the scope, of subclause C had to be decided in order to answer the question whether the golden victory overriding compensatory principle applied to a contract containing the default clause. So you can't divorce the two. I'm going to start with the judgment of Lord Sumption and with the passage beginning on page 532. In paragraphs 26 and 27 on page 532, he made two general observations about damages clauses which are important. So starting with paragraph 26, he made the point that a clause such as the default clause, this is towards the top of the paragraph, its purpose is to provide a mechanical formula in place of the more nuanced and fact-sensitive approach of the common law. He emphasized that it's inherent in such a clause that it may produce a different result from the common law, and therefore there can be no presumption that the parties intended the clause to produce the same measure of damages as the compensatory principle would produce. It cannot therefore be said that Lord Sumption's approach to interpreting the clause started from a presumption that it should be given the same meaning as the common law where possible. He started from the opposite presumption. The second important observation...
We have to look also what he says at the bottom of that paragraph.
Yes, he also says that it can be assumed not to have intended to operate arbitrarily.
For example, by producing a result unrelated to anything which the parties can reasonably have been expected to approximate to the true loss. Yes,
he does. He says, in the absence of clear words. Mm-hmm. Now, of course, there are some some forms of clause which bear no relationship whatsoever to actual loss, and the most notorious of those is invoicing back clauses, where it can result that the innocent party has to pay the repudiating party because there is simply a mechanical formula in the invoicing back clause that produces that result, and clearly that bears no relationship to any loss. So that observation about no intention to operate arbitrarily has to be read subject to looking at the language of the clause and the context. And clearly there is a middle ground between not adopting the common law in toto and operating completely arbitrarily, and that is a middle ground of an acceptance of commercial risk that commercial people might be willing to take. The second proposition is in paragraph 27, first line of the paragraph. Such clauses are not necessarily to be regarded as complete codes for the assessment of damages, and that is, of course, very important to the conclusion that Lord Sumption then goes on to reach about the scope of the default clause, because he says that it isn't a complete code. His fundamental conclusion about subclause C is in paragraph 32 at page 534. In paragraph 32, he says, towards the bottom of the page, last three lines, clause 20 is not sufficiently comprehensive to be regarded as a complete code covering the entire field of damages. Subclause C covers the same territory as sections 50, subsection 3, and 51, subsection 3 of the Sales of Goods Act. And subclauses A and B cover the territory occupied by common law principles regarding the mitigation of losses arising from price movements. But this is very far from the entire field. These provisions bring a valuable measure of certainty to issues arising from price movements, which have given rise to difficulty and dispute at common law for 150 years. This is a valuable purpose which the clause achieves, whatever the answer to the question now before us. But clause 20 is not concerned with bases of assessment which do not depend on the terms of a notional substitute contract or on any determination of the market price. And then a little further on, by letter C, he says it does not deal with any other aspect of mitigation. It therefore leaves open the possibility that damages may be affected by a successful act of mitigation, such as an offer from a defaulter.
He probably means market price or value. It's an expression he uses elsewhere.
Yes, because he, as he explains in paragraph 28, he places weight on the fact that the clause doesn't, in subclause C, the second limb, doesn't refer to price, it refers to value. So when he's saying market price or value, market price is a reference to subclause, potentially to subclause A. Value is a reference to actual or estimated value.
Are you coming back to paragraph 28.4?
Yes, I was going to. What I was just going to emphasise there in relation to paragraph 32, the last passage between C and D. So, for example, one of the examples of an act of mitigation that would fall outside of subclauses A to C, but which would be capable of being taken into account applying the compensatory principle, is the Panyan and Corbiza example of a defaulting buyer who then has the opportunity to repurchase the same goods at auction at a much lower price, and does so, and thereby reduces their loss or eliminates it altogether. That's his reference to an offer from the defaulter which it would have been reasonable for the injured party to accept. So that is showing that the analysis here is that subclauses A to C have a relatively narrow compass, and they don't exclude other aspects of mitigation, but in the territory they cover, which is the contract versus available market measure, to use a shorthand, they are a complete code there, and you have to apply them. Which takes me back to paragraph 28 at page 532 to start with. By letter J, 4 or 5 lines down, paragraph 28, he says, but given the importance of the GAFTA default clause, it is right to deal with it. Pausing there, I suggest that that is a statement which makes it clear that the observations were intended to be relied upon. There would have been no need to deal with them unless the intention was to give guidance which could be followed by the users of the form. In fact, if it wasn't to be relied upon, it would have been wrong to deal with it. Then the key passage is clearly subparagraph 4 on the bottom of page 533. And in subparagraph 4, what Lord Sumption is emphasising is not the extent to which subclauses A, B, and C are the same as the Common Law and the Sale of Goods Act, but the extent to which they differ from them. And he deals with two differences. The first is to do with the date of assessment in the context of an anticipatory breach, which isn't the problem here, although it was relevant to the Bungi and Nadera factual situation. And the second...
If you take it in isolation, when he says that the first difference is the injured party is not required to mitigate by going into the market, that isn't a difference, because, of course, in the common law, you don't have to do that.
Yes, yes, that's not a different difference in that sense, but what he's linking that with is with the date. So, yes. In the common law situation, if you had an anticipatory breach, yeah. and it would be what a reasonable person would do in mitigation is go straight out into and buy or sell, then that is the date by which you should have done that is the date for assessment. But what he's saying is, under this particular structure, if you don't buy or sell against under subclause A, and you wait until the actual time for performance has elapsed, then you can't be criticised, and the assessment of damages will not be by reference to the date when you should reasonably have mitigated. It will be by reference to the actual default date. So that's the point.
That's because of the importance of default date.
Yes.
Scheme. Is that right?
Yes, quite, yes. And in a sense, since the default date, even in Bungi and Nadera, had actually been agreed to be, or found by the tribunal to be, before the date for performance, what he was actually saying was that was not correct on a strict analysis of the clause. But I'm not sure it matters.
Did the version of what's now, I think, clause 25 have the same default provisions as the one we're looking at?
I'm not sure, because that's the whole of the clause is, well, the clause itself is set out at pages 524 to 525, and there is no quotation there of an equivalent provision about date of default. So far as we know, no, but that does depend on whether the clause is quoted in its entirety or not.
Yes, thank you.
But I would say that the form in which these clauses appear in different contracts does tend to vary. So it's quite conceivable that one form of the contract might have a provision about the default date, like the one we've seen, and another might not. And of course, we've seen that from the Eurometal and the caloric, you can see that also that different formulations of the effectively subclause C paragraph were in use at around the same time. So one using our actual estimated value and one using price or equivalent. So I've dealt with the first difference from the common law paradigm. The second, at the foot of the page, the second is that if the injured party has not in fact gone into the market and made a substitute contract, the contract price falls to be compared not with the market price of the goods, but with their actual or estimated value. This may be assessed by reference to the market price of different but comparable goods, for example, goods of different origin or shipment date. Now, in relation to that, what Lord Sumption is saying is that there does not actually need to be an available market at the date of default in order to apply the second alternative under subclause C. The value may be assessed using comparables, as he says, such as goods of different origin or shipment date. He's here discussing a difference from the common law, so he can't simply be talking about the kind of evidence that could be used to establish the available market measure. Otherwise, that wouldn't be a difference, because clearly, even under the Common Law and the Sale of Goods Act, you can use different evidence to work out what what the price would have been on an available market. For example, if you can say there were willing buyers, but there were no transactions because there were no willing sellers at that particular moment.
Or you can deduce what a willing buyer would have paid from some other evidence
Quite,
which is
yes.
similar but not identical.
Quite. It all depends on the market and the commodity. Sometimes it's very easy to work out from other evidence what a market price should be.
So what is the difference that he's getting at there?
He's getting at the difference is that the second alternative in subclause C, actual or estimated value, doesn't require there to actually be an available market at the date of
Then
default.
nor surely does the common law.
No, the common law
He's talking
does.
about departures, as I understand it, from the common law. He's talking about two main differences from the common law paradigm.
But the common law does, or the Sale of Goods Act does require there to be an available market if you're going to apply the Section 50, subsection 3, prima facie measure, because that's especially premised on where there is an available market.
Oh, so by common law paradigm, he doesn't mean the common law generally. He just means an aspect of the common law.
Yes.
Paradigm case being the one
Yes.
where there's an available market.
Yes.
Yeah, okay.
Which is where he started right at the beginning of the judgment with general principle.
So is he saying that there's more flexibility to arrive at value in a non-market case?
Yes, yes. And of course, this simplifies the process because you don't have to ask the question, was there an available market? You simply have to ask the question, assuming there was an available market, what would the market value have been? And that takes one issue, which can often be a vexed issue, out of the equation, which is an advantage, or at least might be perceived to be an advantage.
How can you assume a market?
Well, if there is no available market, you can work out, you can estimate a value for the goods, even though there's no available market. For example, by working from different evidence. So, if you have goods being sold CIF one country, and there's no available market in CIF goods for that country, you might be able to work it out by looking at a price for CIF goods to a neighbouring comparable country.
But you start with looking for an available market, don't you? Because he says subclause C covers the same territory as 53 and 51.3.
Well, you are looking at a market valuation, but if there is no available market, you can get to a market valuation by a different route. And then looking at how this interpretation was relevant to the golden victory point, going back to, or looking down the page at paragraphs 31 to 32 on page 534. In paragraph 31, he makes the point that subclauses A to C constitute an elaborate, indeed a complete code for determining the market price or value of the goods that either were actually purchased by way of mitigation or might have been purchased under a notional substitute contract. But the clause does not deal at all with the effect of subsequent events which would have resulted in the original contract not being performed in any event. And so the answer, as I said, to the golden victory issue is bound up with the construction of subclause C, and the concept of assessing damages by reference to a notional substitute on the same terms as the repudiated contract is critical to that, because it provides an explanation of why the buyer has suffered no loss. Because if the buyer had entered into a substitute purchase on the date of default, it would have contained the same prohibition clause as the original contract, and it would also have been cancelled. And so that's the logic. And we see that from page 530. By letter J in paragraph 22. The occurrence of the supervening event would have reduced the value of performance possibly to nothing. Oh, sorry, perhaps it's the previous sentence. Yes. But where after that date some supervening event occurs which shows that neither the original contract, had it continued, nor the notional substitute contract at the market price would ever have been performed, the concept of crystallizing the assessment of damages at that price is unhelpful. And the assumption there is that they both have the same term in them. Turning then to Lord Toulson, he dealt with the issues in reverse order. So he dealt with the default clause first. And if I could ask you to look at paragraph 59 on page 541. In relation to subclause A, Lord Toulson favoured the view that subclause A is premised on a resale or repurchase on the same terms as the original contract. So we see that from para 59 by letter C, which is all in the context of subclause A. Another answer would be that under clause 20, subclause A, the replacement goods have to be precisely the same, and by letters D and E, he gives the answer, which he says he favours the clause being premised on there being an available market. What is notable about that approach is that immediately in his construction, Lord Toulson proceeds on the basis that the valuation of the contract goods under the default clause presupposes valuation on the same sale terms. Particularly in the last line, which presupposes that they are identical. And then carrying on in paragraph 60, he notes in the first sentence that the hypothetical contract on which the buyer's claim for damages was based was on identical terms save as to price. And then he goes on to prefer the view that the clause is concerned only with placing a mathematical value on the goods. That's between G and H. And in para 61 by letter J, he says that's the view that he thinks is the more reasonable interpretation. In my view, the second, or if I'm wrong, the third is a more reasonable interpretation. And the explanation for taking that view is just above. I do not consider that the language of the clause is sufficiently clear to have the preclusive effect for which the buyers contend. And that feeds into his conclusion in para 62 on page 542.
One of the interpretations that he prefers, second or namely the third, is that the clause has sufficient flexibility to make a fair adjustment in the assessment of what has been lost.
Yes, and that's his second preferred option in relation to subclause A. And in a sense, it doesn't matter for his analysis which of those he adopts. And as I come on to say in a moment, I'm not sure it matters for our analysis which one adopts in terms of subclause A. But just to take two more points from Lord Toulson. Firstly, paragraph 62 on page 542, he also says that the clause doesn't preclude the operation of common law principles regarding mitigation. And so again, that's similarly to Lord Sumption, limiting the scope of subclauses A to C to contract market price issues and nothing else. And in relation to general principles,
your position is that the common law principles of mitigation of loss aren't taken into account in applying these clauses, but are applied separately from these clauses?
Yes, save in relation to deemed mitigation arising from the notional resale or repurchase at a market price or a proxy for a market price on the same terms. The final point I just wanted to pick up from Lord Toulson's judgment, page 546, paragraph 82, the paragraph where he emphasises in relation to measurement of damages by reference to an available market. The second point that he emphasises, it presupposes that the substitute contract is a true substitute, and that's another reference to a substitute on the same terms. So to draw the threads together in relation to Bungi and Nadera, the ratio of Bungi and Nadera is that subclauses A to C of the default clause are concerned solely with determining the market price or value of the goods that were either actually purchased by way of mitigation or might have been purchased under a notional substitute contract, so that they don't address or exclude the consideration of supervening events other than price movements which operate to reduce or extinguish loss. But I do say that the requirement that the notional substitute contract be on the same terms as the original contract, save as to price, is so central to the reasoning of Lords Sumption and Toulson with regard to the Common Law, the Sale of Goods Act, and their support for the majority in the Court of Victory, that it's not possible to interpret the words actual or estimated value of the goods as meaning anything other than value on the same terms as the original contract without inconsistency with Bungi and Nadera.
Does Lord Sumption make that point in the context discussing Clause 20 itself?
Well, he
28.
He does by implication, because in 28.4, when he says perhaps not when he says generally, perhaps not in 28.4, that section, it's perhaps in 32. Yes, sorry, bottom of page 534, when he says that clause 20 is not sufficiently comprehensive to be a complete code, but it does cover, subclause C covers the same territory as sections 50 subsection 3 and 51 subsection 3. He is then referring back to what he said about sections 50 subsection 3 and 51 subsection 3 in paras 12 to 14, which in turn referred back to the common law and was all premised on a notional contract on the same terms. So yes, if you follow the reasoning back, that is what he's saying. So I was going to touch briefly on the consistency.
I've just noticed, I don't know if it's any relevance, on page 536, that all the others agreed with Lord Toulson.
Well, they agree with
Yeah, they
both.
agree with both.
Oh, do they?
Yeah. It's one of-
I'm so sorry,
one of
I
those
missed it at the earlier point.
Yes.
Yeah, fair enough. Just make it easy.
That does raise the question.
Yes, quite.
if you think there's a difference.
Yes.
That does happen.
Well, that's often, yes, it's not
This is quite a
unusual.
good indication there may not be a difference, but not an irrebuttable presumption. Yes.
Everybody agrees with everybody except for Lord
Yes.
Sumption and Lord Toulson don't agree with one another, other than that Lord Toulson agrees with Lord Sumption's conclusions.
Yes.
So I was going to turn on very briefly to the relationship between subclauses A and C, because Sharps admits that subclause A sales don't have to be on the same terms as the original contract, therefore subclause C second limb sales also do not have to be on the same terms. Well, firstly, I say that the premise that subclause A sales don't have to be on the same terms as the original contract may not be correct. And I've shown you what Lord Toulson said about that at paragraph 59. And Lord Sumption certainly doesn't say anything inconsistent with that. But the default clause is silent about the principles on which the tribunal should exercise its discretion whether to use the subclause A price or not. And in circumstances where there is no express guidance or instruction in the clause, one answer might be that this is a very wide discretion, which is only limited by essentially, I suppose, Braganza principles, not in bad faith, not irrationally, not taking into account a wholly extraneous consideration, but that otherwise a decision to adopt subclause A couldn't be challenged. And in a sense, that shows why subclause A is a red herring, because if there is a subclause A sale or purchase against and it's not challenged, that determines the loss. And then no one will ever ask whether or not it was on the same terms as the repudiated contract. If it's challenged, the tribunal still has a further discretion whether to accept it, and that seems to be a very open discretion. So again, how could you challenge that decision on the basis that it was erroneous in law? The only point where an error of law or question of law seems to arise is in relation to the meaning of actual or estimated value, which clearly has been treated as being a question of law because we have Bungi Nadera and the Eurometal and the caloric. That brings me on to the Eurometal, which is at page 548. We've already looked at this case, so I'm not sure it's necessary to go back over the facts. Just to pick up one point which was raised yesterday. So if we turn to page 556, reference was made to the sentence at the end of the penultimate paragraph on page 556. Nothing in clause 26 entitles the Board of Appeal to award the seller any loss in excess of the ordinary measure of damages. And it was raised as a possibility that this was a reference to general common law principles. I would suggest that that was not what Mr. Justice Lloyd had in mind. What he had in mind was the particular structure of this clause, which if we go back to the clause two-thirds of the way up, that we see that halfway through the clause there is the provision such damages in the absence of special circumstances shall not exceed the difference between the contract price and the market price or its equivalent on the day of default. And then 2 lines down, where however any special circumstances in the opinion of the arbitrators or court of appeal exist, the latter may in their sole and absolute discretion award to the buyer such sum in respect of loss or profit so suffered or liability so incurred as they or it shall think fit. So this is a clause which differentiates between the seller and the buyer. The buyer, in special circumstances, can recover additional or consequential losses, and that is envisaging the possibility of losses on a subsale that the buyer has been locked into and is unable to perform because of the default. But the seller's losses are limited to the difference between the contract price and the market price or equivalent measure. So that is what the observation about Clause 26 was getting at, and that was a pertinent observation because, as my Lord Legate observed yesterday, what this case was really all about was an illegitimate attempt to recover demurrage, which was irrecoverable under the clause because of the shall not exceed language, by reducing the resale price and thereby effectively getting the demurrage by the back door. And so that's what all the discussion about demurrage was about. But the important language for our purposes was the emphasis on comparing like with like, which is at page 557. Two-thirds of or halfway through the first full paragraph. What is meant by loss? It means loss which is not too remote in law. In most cases, such loss would be represented by the difference between the contract price and the resale price. But here, the resale price contained hidden elements. First, there was the option to take delivery in Venice. In arriving at the loss on resale, it is essential to compare like with like. And second, there was the obligation to pay the demurrage. So the essence of this decision was that the price at which the resale took place to SEAT was rejected because it contained the hidden elements of the option to discharge at Venice instead of La Spezia and the liability for accrued and future demurrage. And so it was being rejected because it wasn't on the same terms as the original contract. So the short point about this case is that it's wholly consistent with our case that under the default clause, it's essential that the substitute is on the same terms as the original contract. What Malone and Friend sought to rely on was the words in the concluding paragraph on page 557, I would therefore answer the questions of law, and the reference in the next line to the difference between the contract and market price for the cargo as it lay at La Spezia. But the words as it lay at La Spezia, which he takes as analogous to as is, where is, simply will not bear that weight. And what is really significant about the case is the statement of principle about the necessity of comparing like with like. There's also a significant point in that there's no dispute that the goods in this case had been appropriated and shipped, but there's no suggestion that that affects the analysis and that it means that you are not required to compare the original contract with a like-for-like substitute. This is the only non-acceptance case under the default clause, which is before the court. So it's the only case which, in a sense, might be said to be directly on point, and it supports Viterra's construction, not Sharp's. The final case is the caloric at 878. In this case, there was no substitute purchase, so this was essentially a subclause C case, and subclause C was materially in the same form as the present case. See at page 880 in the left-hand side. My learned friend showed you yesterday the two competing cases at the top right-hand side of page 880, Mr. Hallgarton's case and Mr. Johnson's case. The key passage is at page 881 on the left-hand side, which we also looked at yesterday. The two paragraphs at the bottom of the left-hand column on page 881, where Miss Justice Lloyd discussed how the Board of Appeal might have arrived at a value of the goods which was lower than the contract price. The second option was to take the lowest Nidera price, Nidera having offered a resale but on a substitute sale but on later shipment terms, and adjust it for the fact that the port would be open by the time the goods arrived, and the demurrage under that contract would therefore be 0 or much less than under the original contract because of the later shipment date. That is entirely consistent with Lord Sumption's approach of valuing by reference to goods of different shipment date. The first option of taking a landed value and working back is a little difficult to explain because it involves a degree of retrospectivity, which is rather difficult to square with the idea of assessing as at the date of default. But the important point, I would say, is that the emphasis on the relevance of accrued demurrage to the estimated value of the goods is because the value of what has been lost by non-delivery has to be assessed by reference to both the terms of the repudiated contract and the accrued liabilities under it in order to avoid compensation, overcompensation. In other words, the buyer would have paid a price of X plus demurrage of Y for goods which would have been discharged on date Z. Deemed mitigation involves the buyer purchasing substitute goods on the same terms, including as to demurrage. But if shipment would be later under the substitute, you adjust it back and take account of the demurrage which would have accrued under the original contract. In a sense, what this is doing, another way of looking at it, is to say that instead of taking the demurrage into account on the price side and adding it to the price that would have been payable under the original contract, you subtract it from the market valuation side in order to get a fair result. But the overall outcome is the same as the one that I'm contending for, which is that you're comparing with a notional substitute on the same terms, and you're doing a like-for-like comparison. And that was all that Miss Justice Lloyd meant by his insistence upon the goods, meaning the goods appropriated to the contract, and no more weight can be placed on it than that, because this is a case of non-delivery, not non-acceptance. So the notional substitute contract doesn't involve the same goods. So again, this is a case of fastening on a particular use of language in the authority and trying to put more weight on it than properly it can bear. So I say that the Eurometal and the caloric are consistent with Bungi and Nidera in emphasising the importance of assessing the value of what the innocent party has lost by reference to the terms and conditions of the original contract. That leads me on to my final heading: are there circumstances in which actual or estimated value is not to be determined by reference to a notional substitute contract on the same terms as the original, and if so, what are they? This is really by way of a sense check for our construction. In the arguments, essentially 3 possibilities have been raised as to circumstances where the notional substitute would not need to be on the same terms as the unfulfilled contract. The first is a case of actual breach as opposed to anticipatory breach. The second is a case where the goods have been appropriated or shipped as opposed to cases where they have not. And the third is cases where there is no available market as opposed to cases where there is an available market. So turning to the first, actual breach, there's no reason at all why a notional substitute on the same terms as the unfulfilled contract shouldn't be the relevant proxy in a case of actual breach as opposed to anticipatory breach. It makes no difference at all to the suitability of this basis for assessing the loss of bargain, and I would note that both the Eurometal and the caloric were cases of actual breach. The second possibility is where goods have been appropriated or shipped. That is also not a principled point of distinction. Under the Common Law and the Sale of Goods Act, damages can be assessed by reference to a notional substitute after appropriation or shipment. Makes no difference. The limiting factor under the Common Law and particularly Section 50, subsection 3, will be whether there is an available market. But that is not coterminous with whether the goods have been appropriated or shipped. So, for example, in a C&F contract, there clearly can be an available market for goods that are C&F afloat after they've been shipped. And we see that, in fact, both, again, the Eurometal and the caloric involve at one stage or another of the facts sales afloat on C&F or CIF terms. So neither appropriation nor shipment are the Rubicon for the availability of a market or the application of the notional substitute on the same terms. And there's also the question, well, if you're going to look at appropriation or as being a Rubicon, why in an FOB context, prior to appropriation or shipment, would you say that you do have to look at a substitute on the same terms? So if you have an FOB seller who has goods in tank, let's say oil, that they intend to use for a shipment, but they haven't yet appropriated, and there is an anticipatory breach or repudiation before the time for appropriation and shipment has occurred, why on Sharp's construction shouldn't that seller be able to sell on completely different terms, let's say an ex-tank sale as opposed to FOB, and use that to measure its loss? But that's not something which seems to be accommodated by Sharp's construction. The third possibility is that the dividing line is between an available market and no available market, and I say, as a matter of construction and as a matter of Lord Sumption's decision in relation to subclause C, actual or estimated value applies where there is no available market. Firstly, because that's inherent in the language, the use of the word value rather than price or market price. And second, it's inherent in Lord Sumption's construction, and I've shown you the passage, particularly 28, subparagraph 4. And thirdly, and most importantly, it's an aspect of the simplification of the assessment of damages achieved by the default clause. I've shown you the passage from Lord Sumption in Bunge, expressing that as an acceptable aim of a clause such as this. It has a commercial purpose, which is to take a debate about whether there is an available market out of the process. And it's notable that we see no discussion about whether there is an available market in any of the three key cases, in Bunge, Eurometal or caloric. And in Bunge, that surely would have been a particularly pertinent point, because there would have been no market in wheat being sold FOB Russia at a time when there was an export ban from Russia. Yet there was no difficulty in that case, it seems, in putting a valuation on the wheat, which led to the original award of damages. So essentially, what the second alternative in subclause C is doing is providing a simple, predictable, easy to operate mechanism for performing a financial closing out of a trade transaction. And it may be that that doesn't always exactly reflect the Common Law and Sale of Goods Act result, but that is part of the rough with the smooth that traders are likely to be willing to accept, and it's only a very limited modification because both Lord Sumption and Lord Toulson accept and expressly find that other principles relevant to the compensatory measure lie outside of the subclause A to C mechanism and can still be taken into account. So this is not a clause overall which ignores or excludes other factors relative to whether there has been proper compensation or not. So I say, by way of conclusion, that the desired outcomes of certainty, consistency and predictable point towards the interpretation which should be the same regardless of where in the life cycle of the transaction the default occurs. And so there is no principled reason for saying there is a switchover from a notional substitute on the same terms to some different basis of assessment at any of the points which have been identified as a potential switchover point in the argument. Miles, unless I can assist further,
how do you say we should answer the question posed by the posed to us?
I say you should answer it in the way we answered it in our written case, which is not to answer the question head on, but to answer it by reference to what we say is the real issue, which is
where do we find your answer? Sorry,
yes.
I've forgotten that.
Oh, well, I hope now that having said that, I can actually, it'll be in our supplementary bundle, which is the only place where our supplementary written case is. And it's para 5, page 85.
Sorry, para 5 of your supplementary
case. Page 85 of the supplementary bundle, para 5, applying those statements, the actual, you can obviously ignore that, the actual or estimated value of the goods on the date of default means the price assessed by the GAFTA tribunal based on a notional substitute contract entered into on the same terms as the unfulfilled contract, saves to price.
So if we were against you on cross appeal, what do you say should happen?
Well, then there would have to be a remission based on the finding on the question of law. At various stages, Sharp has suggested that various courts could substitute their own view as to the loss, but that's completely unsustainable because there are no findings. And also, well, no doubt the same question will be put to Mr. Karia as to what he says the answer to the question is. But I have emphasised the potential difficulties that might have arisen from the Court of Appeal's answer. So it is very important that whatever answer is given, if there is to be remission, is one that is capable of being applied easily by a tribunal.
Didn't the GAFTA Appeal Tribunal treat it as a consequence of the meaning of the clause that they had to ignore the fact that the goods had been customs cleared?
I'm not sure that one could go quite that far because they proceeded on the basis that it had to be a CNFFO valuation. They only had one set of data for that, which was the data provided by Viterra. So it's not entirely clear that they took any position on that. Nor is it clear.
They seem to rule out the evidence adduced by the buyers on one of the reasons given was because it was for what would be paid for customs cleared goods.
Well, that
One might have thought that was exactly what we were dealing with. Whether the term said C and FFO, I mean, the goods were there, customs cleared, and that surely is a governing feature in what people are going to pay.
Yes, but conversely, it's a governing feature of the original contract terms that customs clearance was not something for which the seller was responsible, and also not something which the buyer was obliged to do.
Well, that seems to me to be getting perhaps to the nub of what the real issue is, given that the buyer had done it here.
Well, that in a sense has always been the real, as it were, as the court first instance judge put it, the real economic issue. But then it's difficult to see quite how that's taken into account in Sharp's formulation of the question of law either, because there's no reference there to customs clearance.
Well, there is a reference to
goods being landed, but that doesn't.
Well,
where they are located.
But again, that comes back to the point, there's a distinction between location and the terms on which you can sell them.
Well, that's true. And but one thing that I don't think you're seeking to justify is that B would be a measure of value that one would sensibly come up with applying the compensatory principle.
If all of the common law principles that had been in play, and depending on which arguments were put to the tribunal, which is a very important limiting factor, one can see that there might have been interesting arguments about how the customs clearance should be factored into the exercise. And those arguments would probably have focused around the Westinghouse principle, I would suggest. The Panyan and Compuisa's type analysis whether you have a connected transaction or not. But that's not the way it was put. That's certainly not raised by the question of law.
You say that falls outside the default clause?
Yes.
And we're only concerned with the default clause?
Quite, yes. And that's consistent with what Lord Sumption said, because he referred expressly to the possibility of a mitigating transaction entered into where there was the defaulter offered to repurchase the goods. And that's exactly the Panyan and Corbiza situation. And as we see from the Elena D'Amico, that's a British Westinghouse type situation.
It's not an offer here, it's a fact.
No, I know it's not that we're not in exactly the same fact pattern, but I'm saying conceptually that's where it would potentially fit into the analysis.
So what would the argument be as to why you should ignore the current situation of the goods? Well, in terms of who had paid what, where they were, and whether they've been customs cleared or not.
Well, firstly, there's a factual difference between the two cargoes. One, in relation to one, the customs duty was imposed before the termination, and in the other, it was imposed after the termination, but while the goods were still wrongfully being not released to Viterra. So there might be...
That's the question of the import tax.
Yes.
I'm not talking about that.
Oh, sorry.
I'm talking about whether the goods have been customs cleared or not.
Well, that's the same issue, isn't it?
Is it?
Yes. So
why?
Well, because that's why the goods are said to have increased in value on the domestic market as opposed to goods being bought on the international market, which would arrive later and the customs duty would have to be paid on them.
Well, on any view, we're looking for a substitute on the date of default.
Yes, quite.
Not a substitute that arrives in 2 months' time.
Yes.
Which is the substitute the arbitrators awarded.
Well, they assessed the value by reference to that. They did that.
I mean, the very measure they awarded strongly suggests something's gone wrong with their process, because they've awarded a measure that bears no relation to the commercial reality of the situation. On any view.
I understand that concern, but the answer is that the argument about how that situation should be addressed lay outside subclause C.
Where in the contract did the answer lie? Which paragraph?
Oh, in the contract, the original
I
contract.
suppose it lies in
showed-
B, on your view, does it? It's subclause B.
Oh, do you mean the answer in terms of how should it?
You're trying to
Yes.
put matters into a straitjacket. That in C you have to look at things this way.
Yes.
But there are other principles of mitigation and so on that can be taken into account. Where in clause 25 does one do so?
Well, clause 25 doesn't expressly address them, and that's the point of the basis for the decision.
But where's the simplification then? If the poor trader has to carry out an exercise in clause 25 and carry out a separate exercise outside clause 25, I thought the whole idea of clause 25 was to give to give in general terms a code by which you could settle your dispute.
Because the simplification arises because in the majority of cases, the dispute is going to be about the value or market price of the goods. And that issues relating to those market price movements are dealt with by subclauses A to C. And that's the mechanism, the simplifying mechanism. And one of the simplifications is the avoiding the need to debate whether there's an available market. The other types of situations, such as the supervening export prohibition, a compensating transaction that's entered into because of special circumstances. These are all highly unusual situations that are only going to arise in a minority of cases, and so it doesn't detract from the simplicity of the clause to say that the clause doesn't exclude those issues from being raised where they fall for consideration. But since in the vast majority of cases they won't, in the ordinary run of things, the clause is a simplifying clause.
Thank you.
My lords, unless I can assist further, that was all I was going to say. My junior was going to very briefly deal with some points on construction of standard terms. I think this might have to be a 2-minute submission, but just to touch on that very briefly.
Yes, Ms. Simons.
I'm grateful. May it please the Court, I was just going to take a very short point on the way in which the Court of Appeal approached the exercise of construction and the general approach to using authority when construing a standard term. The origin of this point comes from the way that Sharp has put its written case. If you turn to page 73 of the supplementary bundle, you have under heading F, Sharp's third alleged error of law.
So, sorry, this is the Respondent supplementary bundle.
With apologies, it's our supplementary bundle, the Appellant's.
Right.
Your supplementary bundle.
Sorry, which page?
Page 73.
Yes, error 3.
Yeah.
Error 3, Sharp say, is adopting the Bunge and Nadera substitute contract analysis, which does not apply, which I say is the error that my leader has addressed you on. Then, if you turn to page 63 of Sharp's of the supplemental bundle, 63, you have Sharp's first alleged error, which is forcing the construction of subclause C into the straitjacket of the dicta in Bunge and Nadera. The essence of our submission here is that error 1 does not stand up alone, irrespective of the outcome of error 3. If the Court of Appeal approached Bunge and Nadera correctly as a matter of analysis, then there is no standalone error of law because they placed too much weight on that correct analysis. In fact, we say, when construing a standard form contract with exactly the same wording, one might expect a certain level of weight to be placed on precedent. I'll take the Court only to 2 cases very shortly because I know we're short on time. The first is a statement by Lord Diplock in the NEMA at page 945 of the main electronic bundle. Here towards the bottom of the page, Lord Diplock says, "It is only if parties to commercial contracts can rely upon a uniform construction being given to standard terms that they can prudently incorporate them in their contracts without the need for detailed negotiation or discussion." Here, Lord Diplock is giving the underlying rationale for the guidance he'll give later in the judgment, which is about using a lower merit threshold where a case raises a general issue as opposed to a one-off issue. The only other authority which we would highlight is the Sea Queen. I won't take the court to it because I know we're short on time. I'll just give you the reference. Sharp rely on the Sea Queen under error 1 of their case, but we say this is actually an example of a court using a precedent to interpret a standard form. And at page 884 of the electronic bundle, page 885 of the electronic bundle, at column 1, you will see the court basing its decision on a previous authority that dealt with the same wording, the Laura Prima. I won't take more of the court's time because I know we're short on time, but the short point is that we say error 1 is incapable of standing up alone if the court did approach Bungia Nadera correctly. I'm grateful.
Thank you very much. Mr. Carrier.
May it please your lordship. So I'll seek to deal with the points roughly in the order in which they were made. There was a point made about this is a sale of documents representing goods and not goods. But subclause C refers to valuing the goods. I mean, this is a sale of goods, and what subclause C requires is valuing the goods. And sight should not be lost of the actual words of subclause C. Secondly,
so while you're raising that, a word omitted from the question which we need to supply by interpretation. The word "the" before goods in your possibility A?
It may well be. I do apologize. I think that I would respectfully ask my learned friend to consent to that, otherwise it will be a question of construction. My learned friend says it's anachronistic to look at the location of goods, but this case shows that it isn't. It's absolutely crucial when valuing goods to determine where they are. Cuban cigars in Cuba are worth a lot less than they are in Mayfair. So, in any event, these goods were customs cleared, so they were stuck in India. Now, my learned friend says one has to replicate the detailed terms of the original contract whilst disregarding the location of the actual goods. And that's with respect throwing the baby out with the bathwater. On what basis and where in the default clause does it require the tribunal to ignore the location of the goods when determining their estimated or actual value? Now, my learned friend says he accepted that the default clause, I think he said not subclause C, but as a whole, has an eye on the compensatory principle. But the facts of this case demonstrate that the default clause applied as a whole does not give effect to the compensatory principle if my learned friend's construction is adopted. Similarly, the example that I gave of a similar case, but where the domestic market in Mundra is flooded with a bountiful harvest of lentils, would leave the innocent buyer severely undercompensated. And that, again, is, to adopt Lord Toulson's words, not something one can reasonably expect the drafters of the default clause to have intended. And indeed, once you take your eye off the actual goods in a situation such as this and go to theoretical goods, absent coincidence, the construction adopted by Viterra will always violate the compensatory principle, because it'll either overvalue those goods, in which case the innocent party will be, the innocent seller will be undercompensated, or it'll undervalue them, as in this case, in which case the innocent seller will be overcompensated.
Is the point about terms perhaps a bit of a red herring at the end of the day?
Yes, I mean, it's...
Because would it have made any difference to the value of these goods whether the contract had been assigned by Viterra or whether they entered into a new contract which wasn't on free out terms, etc.?
Yes, well...
related to the goods situated as they were.
Well, my learned friend has not pointed to any particular economically significant terms. And we say it's much more economically significant that they were in a market. In a sense, one can look at the Indian market post the imposition of tariffs as having a little wall around it. And they'd gone in before the wall had been constructed. And now any other goods that needed to come in had to jump over the wall by paying the money. So, but yes, my learned friend has not said, oh, in this particular case, these terms mean that it's much better to actually replicate the original contract.
What I'm saying is, would it have made any difference if the original contract had been replicated on a sale, but it's simply been assigning all the rights of the seller, and that had been the sale?
Sorry, I think yes, I mean, it could have been on the same terms.
On exactly the same terms, exactly. Would it have made any difference to the value of the goods, is what I'm asking.
It wouldn't if you are actually valuing those goods. Because you then have to take into account the fact that they're customs cleared. And indeed, my lord, in paragraph 7.41 of the award at page 247, the tribunal specifically looked at the fact that it was customs cleared and said we can't take that into account because we have to imagine a purchase or sale or purchase on the international market. And that was the argument that was advanced by Viterra and accepted by the tribunal. On the Elena D'Amico, it's not quite clear to us how that helps my learned friend's case, but one does see how differences in terms, insofar as they are economically material, are taken into account. So that judgment case appears at page 772. And this was an award by Mr. Christopher Staunton, QC, and at 776, we see part of his award, and on the right-hand column of 776, we see how the learned arbitrator addresses the question of replicating the Italian flag of the repudiated charter party. My first submission is that the fact that this ship happens to have an Italian flag as opposed to a British flag or a Greek flag is an aspect of quality. And at paragraph 15, the learned arbitrator explains that yes, the charterer wanted an Italian flag. Whether he would have to pay extra would be dependent upon if he let on that that's what he wanted, or if he hid that fact and managed to do a deal. But what's interesting is about 7 lines from the bottom, how he comes to valuing that flag. He says, however, I consider it appropriate to add a small premium for the contingency that their requirement of an Italian flag might to some extent have been perceived by those with whom they were negotiating. That premium I assess at 20% of the difference between 4.05 to 5.30. Accordingly, the market rate for the Italian flag vessel comparable to the Elena D'Amico in March 1973 was $4.30. Now, the reason I cite that is insofar there are any economically significant terms that have not been replicated, and my learned friend hasn't shown you any, arbitrators are perfectly well able to adjust for those differences. And talking about the Eleanor D'Amico was, of course, a charter party case, but one can provide an example of a charter party case where positioning does make a difference. So if you have a contract for a series of time charter trips, for example, or indeed even just a period time charter for redelivery, let's say in Brazil, which for the purposes of the hypothetical assume is not a very favorable position for an open vessel to be, and there's a repudiation and she's redelivered off Shanghai, which is an extremely favorable position because China is exporting so much goods, then that positioning will affect the value of the mitigation charter that that vessel can enter into. With regard to Bunge and Nidera, I have taken you through the relevant passages. My learned friend took you through them in some detail. We submit that he has fallen into the Quinn and Leatham error that the Earl of Halsbury warned against. It is absolutely clear when you read Lord Sumption's judgment, and indeed even clearer when you read Lord Toulson's, that they are directed to the facts before them, namely that there is a premature termination of an executory contract. And that is precisely what one would expect. And that is why, for example, we don't need to turn it up, but in paragraph 28.4 that my learned friend took you to on page 533, the first difference between the common law and the default clause that Lord Sumption considers is what happens in the case of a repudiation. Do you have to go into the market, or do you wait until the date of performance? And your lordships have, in our written case, all the passages where we show that the lordships were focused on the facts before them.
But the reasoning that Mr. Collett relies on is that what they were saying was you can take account of the compensatory principle of mitigation, but it's not, when you do so, it's not within the confines of that clause.
Well, it's very difficult.
And therefore, it's quite a subtle point he's making, but he's saying the arbitrators could have taken into account compensation and mitigation, but it wouldn't have been within the parameters the clause were asked to construe.
Yes. Couple of points on that. Firstly, it's very difficult to see how, in the context, let me back up. Lord Sumption also said, in the field covered by the default clause, it is exclusive. So subclause C covers the difference between contract price and value. And so once you've done that equation, it's very difficult to see how you bring in mitigation, unless you bring in mitigation within that equation. But it may be that there are external things.
Lord Sumption gave examples, like the date being a different date appropriate to sell, or in that case, the subsequent events being relevant.
Yes, and of course...
There are quite a lot of cases.
Yes,
and Mr. Collett's argument is here, well, it's outside the confines of the clause if you take account of...
But why is there any reason to read it in that way when the clause expressly refers to the estimated or actual value of the goods? And the events that have happened are encompassed and covered by those express words. So my learned friend also said that I was wrong to say that the decision of in Bunge and Nidera, the default clause played no part in the decision. The quantification provisions of the default clause played no part in the decision in Bunge and Nidera. The only relevance of the default clause was an argument was advanced that ousted the Golden Victory compensatory principle. That argument was rejected. Therefore, the default clause played no part in the actual decision that the Supreme Court came to. Again, my learned friend had raised very recently that somehow the increase in price as a result of prior customs clearance would fall outside Clause C. And I recall the debate or agreement I had with Lord Leggett that prices move up or down for various reasons, with war, pandemics, tariffs, taxes, prohibitions. And one doesn't need to look at the cause. A hurricane can affect prices. One can't say, well, a hurricane wasn't something that was catered for in the contract. It was fortuitous, therefore you can't get the benefit. So there's nothing in that point. Lordships would just bear with me.
Did the importation tax take effect according to whether the goods have been cleared through customs or not?
Yes, I mean, the precise date, one can look at the award as to when I think they were announced and they took effect later.
I see.
But my learned friend was talking about, one came in before and one came in after our default. But no, that is an irrelevant date. The only date is the 2nd of February 2018. That is the date of default. They could have claimed anything, we could have claimed anything, doesn't matter. The arbitrators have decided the 2nd of February 2018. The tariffs came in, I think, in November, December time, before that. So...
right, so that, yeah.
Yes. There is... I think your lordships have my point, and I think Lord Leggett said, does the mitigation have to be on completely identical terms? Well, the passage I've shown you from the Eleanor D'Amico shows where it isn't. Arbitrators are well used to adjusting the prices. I think I'm almost there, if your lordships would just bear with me.
Yes, certainly. Don't feel you're rushed.
My learned friend said, well, you shouldn't change the law as set out in the dicta in Bungi and Nidera because the market has acted on it. Well, first of all, that's a bootstraps argument because that assumes that the correct interpretation of Bungi and Nidera is the one that my learned friend propounds. And anyone reading, and I suspect there aren't that many traders who read it as their bedtime reading, will understand that these are dicta and understand what the ratio of that decision is. Secondly, there's no evidence of any market understanding, so your lordships can't assume that there is any. And thirdly, it's a question of law. The other point was made, well, you should pay attention to the trade arbitrators' construction. But it's a question of law, and indeed...
It didn't make much difference in Bungi and Nidera.
No.
Yes.
In this court, anyway.
Yes. And indeed, if one looks at it, it's actually the board's construction that gives rise to complexity and what we say in our case, sort of legal gymnastics. And this isn't what the traders who are involved in the drafting of this clause would have intended.
Well, one assumes that lawyers would assist the traders,
yes,
realizing that the clauses would be operated by traders.
Yes, but it's also difficult to see lawyers who would advise their clients that the goods meant anything other than the goods. So, and just for your reference, Lord Toulson talks about the flexibility for a fair adjustment. I think my Lord Hodge pointed it out at page 541, letter E. My learned friend accepted that clause C is based upon the section 50 subsection 3 and 51 subsection 3 of the Sale of Goods Act, which is based in turn on the common law. Well, your lordships have seen Arno, which is the basis of the common law, and the logic behind that is a buyer left without a seller would go to the nearest market and sell the goods. My learned friend conceded quite frankly that on his construction there would be, to adopt a phrase from my Lord Briggs, no yardstick within subclause C to choose between the subclause A measure and the subclause C measure. So he says, well, you have to rely on bad faith. But that doesn't help. That doesn't help the arbitrators, but more importantly, it doesn't help the litigating parties to settle the case. The purpose, these traders do not want to have endless arbitration after arbitration, because subclause A yields value X and subclause C yields value 2X. And no one can advise you as to which one the arbitrators are going to pick. So, of course, you have to go to arbitration. That is a recipe for litigation and a blank check for some lawyers. So this is not a case where you should advocate bringing in Braganza. My learned friend sought to distinguish Eurometal on the basis that there was hidden demurrage, but he didn't take you to the passages where Mr. Justice Lloyd says it's the market value and the value of those goods. But indeed, I have taken your lordships to the caloric at page 881, column 2, and that's where Mr. Justice Lloyd, expressly explains his decision in the Eurometal and says that he decided it based upon the market value. So if you want to understand what Mr. Justice Lloyd meant, you will find no better guide than Mr. Justice Lloyd. On the caloric, my learned friend took you to certain passages, but ignored the key passages which formed the argument before the judge between Mr. Horgarton and Mr. Johnson, namely whether the valuation should be of the particular appropriated goods, and he held that they should. Unless I can assist your lordships further, those are my submissions.
Thank you very much, Mr. Carrier. Well, we're very grateful to counsel for a very well presented argument, and we particularly appreciate the fact that junior counsel were given the opportunity to address this court. That's a welcome change. We'll consider the submissions and let you have our judgment in due course. The court will adjourn.